Hey guys, how's it going? Hopefully, you are making sense of the coronation that we're now finding ourselves in. Um, Last week, I sent you guys some videos through Classroom that I wanted you to check out. Um, Hopefully, you've had a chance to look at them. Some of them are some student created videos. You are going to have to create those, but with everything that's going on, we're sort of moving quick and you won't be doing those, so you kind of lucked out a little bit. I just want to go over the Section 1 Oaks test stuff, the remedies with you really quick, so that way, pardon me, that way we can sort of move on, and I hope that you have a decent understanding of how this all works. So, remember, Section 1 boils down to 6 words. You have rights, they have limits. Okay? So the idea is that the government can, create laws that violate your charter rights as long as it's reasonable. Okay? Now, go back in time, back into the 80s. There was a guy by the name of David Edwin Oaks. Okay? He was caught just outside London with 8 vials of hash oil, which is a controlled substance, a drug, and a little over $600, $620 or whatever. Anyways, at the time, Canada had what we call the Narcotics Control Act. Now that is gone now, it's been replaced, but under Section 8 of the Narcotics Control Act, what happened is anyone caught in possession of a substantial amount of drugs and 8 individual vials of hash oil qualified. Basically, they were charged with trafficking. Okay, so not just possession of the drugs, but also trafficking. So trying to sell the drugs. Pardon me. Now, the Charter of Rights and Freedoms had just been created. It came out in 1982, so it was in and around the same time. So it was still really new. People were trying to sort it out, trying to figure things out. And Section 11D of the Charter of Rights and Freedoms, sorry, I'm looking at my notes here on the other computer, basically says that anyone who's charged with an offense has the right to be presumed innocent until proven guilty. So, under the Narcotics Control Act, okay, Section 8 of it, it said that provided those in possession of narcotics would be presumed to be in possession for the purpose of trafficking unless they proved otherwise and would be convicted. So basically, Section 8 of the Narcotics Control Act said if you have drugs, we're going to charge you as a trafficker. It's up to you to prove that you weren't trafficking those drugs. So that's a clear violation of Section 11D, right? Innocent until proven guilty. One of the main ideas in our justice system is the idea that it's not up to you to prove that you're innocent. It's up to the Crown to prove that you're guilty. So with this case, we had an issue because Oaks had a charter violation. His charter rights, his right to innocent until proven guilty, were being violated by Section 8 of the Narcotics Control Act. Now, judges in Canada like rules. Judges in Canada like procedures. They like knowing how to handle certain circumstances. So we've talked about common law, we've talked about precedent, and Oaks is a precedent-setting case because the judges sort of looked at it and went, wait, we've never had anything like this with this new charter. So they created a test, okay? They created the Oaks test. The Oaks test is a way of looking at whether or not a law that exists that is a violation of someone's charter rights, okay, whether that law is reasonable or whether it is a violation of the rights, okay? So the law in question was Section 8 of the Narcotics Control Act, that whole idea where you're charged as a trafficker and you have to prove you're not a trafficker, okay? So they created the Oaks test as a way to evaluate any type of law. So it wasn't just for this case, it was all future cases that involve Section 1. And if you can remember way back before March break, I talked about how the Oaks case, this Section 1 case, this Section 1 test, is like the most important case in Canadian history, okay? So, you should already know the stages of the Oaks test. We've been talking about this, but quickly going over it. So, the first thing we have to do is we have to figure out whether or not there is a violation, okay? So, has a law, is there a law that exists that breaks a charter right? Well, clearly in this case, Section 11D violates... Section 8 of the Narcotics Control Act violates Section 11D. So, then we start the actual test. The first stage of the test is called prescribed by law. Is it a real law? Is it written down? Yes, obviously Section 8 of the Narcotics Control Act is a written down law. Then we go to the second stage, which is pressing and substantial. Okay, so the idea there is this something that is important to Canadians, important to society? Well, Section 8, whole idea of it is getting drug dealers off the street. So, of course, that is something that's really important to, something that's really important to Canadians. The third stage is called rational connection. So the idea there is there a rational connection between what the law is trying to do and what it says? Okay, so what it says and what it actually accomplishes. Because sometimes we create a law that, kind of goes around what it actually accomplishes. So in this case, what are we trying to accomplish? Well, we're trying to get drug dealers off the street. Does Section 8 do a good job of getting drug dealers off the street? Yeah, kind of, okay? This one, it actually failed this test, okay? Some people argue it passes. Some people argue it fails this stage. Either way, let's keep going. The fourth stage of the test, okay, is called minimal impairment. Now, if you watch the video from last week that I posted, the Karen Stewart video, she does a great job of talking about this. This is where she talks about construction boots versus ballet slippers, right? So we know that we're violating your rights. We're allowed to violate your rights a little bit, so we can step on them with ballet slippers. What we can't do is crunch on them with construction boots, okay? So in this case, are we violating David Oaks' rights a little bit by saying, hey, you have to prove you're not a drug dealer? Or are we violating them a ton and saying, hey, wait a sec, the whole idea of innocent until proven guilty, well, you know what, it doesn't apply to you. So in this case, that's an absolute fail. This is a huge infringement on David Oaks' rights, okay? The fifth stage. Do the positives of the law outweigh the negatives of the infringement? So basically, this is sort of the pros and cons. So by having this law, what are the pros? Well, we get drug dealers off the street. What are the cons? Well, there's some of those drug dealers, their rights are being violated. So do the positives outweigh the negatives, okay? And in this case, you could probably argue that it does, but it doesn't really matter because it kind of fails rational connection, which is the third stage, and it kind of fails minimal impairment, the fourth stage, okay? So both 3 and 4, it fails. Because it fails, the law is seen as invalid, okay? So here's the problem. So they've come up with this test, and they know that, okay, we've got a law, Section 8 of the Narcotics Control Act, violates all Canadians' charter rights. So what do we do with it? We can't just leave that law. So the second part of what I want to talk about right now is called remedies, okay? So when you think of a remedy, you think of, well, you go to the doctor because you're sick and you get a remedy. You get something to make you feel better, right? You get something to heal you. That's kind of the same idea as what the Supreme Court has the power to do when they determine that a law is a violation of your charter rights. So there's 6 options that they have available to them. So once something has failed the Oaks test, okay, and we know that that law, there's a problem with it, the courts have the power to actually fix that law. So the 6 options that they have Option 1 is something called striking down. Basically, with striking down, they get rid of the entire act. Okay, so the Narcotics Control Act, that was sort of our drug laws that existed in Canada. This is not a viable option because for them to get rid of that means basically that Canada has no drug laws. So they're not going to strike down the entire law. That's just ridiculous. Okay. The second option they have is something called partial invalidity. Partial invalidity means that they take a part of the law that doesn't work and they get rid of it. Okay. So it's kind of like taking a pencil and just crossing out, or some whiteout, some liquid paper, and whiting out that part of the law, just getting rid of it. And that's what they ended up actually doing. They actually said, okay, you know what? We're going to have Section 7 of the Narcotics Control Act. We're going to cut out Section 8, and then we're going to go straight to Section 9. So they literally just cut Section 8 right out of the Narcotics Control Act. Now, a couple other options that they could have had. One is called reading down. Now, reading down doesn't happen very often, but reading down is basically where they take the law and they say, okay, if we interpret this law, if we look at this law and we think about it from this perspective, okay, if we look at it this way, if we narrow down our focus on how we look at the law, then it'll work, and it still fits within the charter, and it's not a charter violation. It's not a rights violation. There's no infringement. Reading down doesn't happen often, okay? Because you're changing the interpretation. You're changing how we interpret the law. The fourth option for them is something called reading in. Now, reading in has only happened a couple of times in Canadian history, or since the charter was created. Reading in, basically, they say, okay, you know what? We're going to pencil something right into the charter, okay? So, for example, gay rights. If you look at Section 15 of the charter, you can't be discriminated based on race, sex, age, mental or physical disability, national and ethnic origin, so on and so forth, but there's nothing about sexual orientation. So that means that technically in 1982, when the charter came out, you could discriminate against someone based on sexual orientation. Well, then there was a case that came out and they went, no, you know what, we can't discriminate based on sexual orientation. So what they did is they read in sexual orientation into the charter. So what they did is they basically penciled in the word sexual orientation under your equality rights in Section 15. The fifth option is something called constitutional exemption. Again, this one doesn't happen very often because, well, it's only exceptional circumstances. Basically what they're going to do is they're going to say, okay, you are constitutionally exempt from this law. So they're basically going to pick on a particular person or a group of people and say, okay, you know what, this whole law doesn't actually apply to you because, you know, it works for everybody else, but it doesn't work for this group, so we're going to exempt this group. We're going to say that this group doesn't have to follow the same laws as everyone else, okay? Again, it doesn't get used often because it's such an exceptional remedy. The last one, and this one gets used probably the most frequently, is called temporary suspension of invalidity. Basically what this one is it says, okay, you know what, we see that there's a problem, but the courts aren't politicians, okay? The courts, their job is to interpret the law, not to change law, not to make laws. So what they do is they say, okay, you know what, we're going to put a timeout on this law. We're going to say, you know what, government, you've got a year. You've got a year and a half. You've got 2 years. We want you to fix this problem. We've identified the problem. We know that there's an issue with how the law is created. It's up to you to fix it, okay? So those are the 6 remedies that exist. Striking down, partial invalidity, reading down, reading in, pardon me, constitutional exemption, and temporary suspension of invalidity. I hope that helps. I know it's kind of a whirlwind tour over the charter. What I've just done in 15 minutes would probably have taken me 75 minutes in class. Maybe video is a good way for me to do this, and I should do it more often. Anyways, stay safe, stay healthy, and enjoy your coronacation.